committees. I understand it's a labor of love. We have a pretty phenomenal community here, very small staff, tight budget, and I'm confident that there's no way that we would be able to accomplish everything that is being done without our committees. So really appreciate everyone. A lot of you, well, just a few of you I haven't quite met yet, but looking forward to working with you in the future, and feel like this particular training will be a really great opportunity and help set the stage for our future work planning, as well as operating with you all. With that, just a couple of housekeeping things. If you have a question and you are in our live studio audience, please say it loud enough that Sam can hear you, and he'll repeat the question so that the folks online can hear. If you are online and you have a question, please type it into the chat and Nate will relay it to the rest of the group. With that, we do have restrooms in the back, fire exits out front and to the sides. And we'll introduce Sam Light with CIRSA. Oh, and there will be a sign-in sheet coming along. For folks that are online, please go ahead and type your name and your committee, as well as any updated contact info that you might have, into the chat box so that we can preserve it as record as well. And then let's go ahead and before Sam starts, let's go ahead and begin with a round of introductions from the group.
I'm on the board of trustees and the liaison to the PRT.
My name is Craig Linden. I'm the regional manager for the Colorado Department of Local Affairs. Filling in for Clay Brown, who's retired, and I'm your interim regional manager. Nice to meet you all.
Scott Dixon, Mayor-elect.
Nancy Dixon, I'm on the PRT committee.
Margaret Peterson, I'm currently Mayor Pro Tem, and I'm the representative for GACG, which is the Pikes Peak Area Council of Governments, and outgoing in 2 weeks.
Sunday King, current trustee and continuing.
Sean Ives, I will be starting on trustees tonight, the planning commission right now.
Nick Gonzalo, incoming member of the board of trustees.
Mike Fry on the planning commission. Rich Bowman, fire mitigation committee. Ron Gans.
John Bell, no committee.
Freshman support. And we follow, I'm interested in volunteering for the planning commission, and I think there's one, because I just come tonight and listen.
Thank you. Nate, would you like to introduce yourself, and then we can open up the mic for anybody online?
Nate Scott, and I'm the town clerk and treasurer and planner until we get a new planner in. So I don't know that the online people are not going to be able to hear their audio very well. So
Would you just like to read who's
I
typed
can
in the
read.
chat, and identify anybody else that's on?
Yeah, Don Walker from the Parks Rec Trail Committee's on, Dan Batten from Fire Mitigation, Lamar Matthews on Planning Commission, and David Douglas of the Fire Mitigation Committee are all online.
Wonderful. Thanks to the folks online who are attending. Without further ado, we have Sam Light, CIRSA.
Thanks,
Want to get that one out of the way, and would you rather hold the other?
I think I'll stay here starting, and we'll see, maybe we can use this for questions. So good evening, everyone. Thanks very much for inviting me down to visit with you all, particularly on such a wonderful evening, just a beautiful drive up to come visit you all in Green Mountain Falls. So as Becky mentioned, my name is Sam Light, and I'm general counsel for CIRSA. That's an acronym for the Colorado Intergovernmental Risk Sharing Agency. And that's a mouthful, so we just call it CIRSA. We're the town's insurance provider for property and casualty coverage. We've been providing that insurance for the town since 2004. A little bit about CIRSA. We're not a commercial insurance company. We're what's called a public entity self-insurance pool. And so we're owned by our members, and our only members, our only book of business is Colorado cities and towns and affiliated entities. We have 282 members, which is most of the cities and towns in the state of Colorado, except for some of the very large ones like the city of Denver and Colorado Springs. They tend to self-insure their own risk, but we provide insurance for most of the municipalities in Colorado. One of the things that we do, of course, we handle the bread and butter stuff, I call it. We make sure you get your coverages placed, your renewals in place, deal with your auto liability insurance for your town-owned vehicles and equipment and so on. And we, of course, deal with the claims that come in, whether it's an auto liability claim or a property damage claim because you had a hailstorm, or a liability claim where some third party believes that the town did some wrong to them and they bring a liability claim. So we handle those bread and butter things. But one of the other things we do is we provide risk management services for our members. And those services are there as much or as little as you would like. But one of the things we do as part of those services is we provide trainings to elected and appointed officials and staff. So I'm the one at CIRSA that gets the wonderful job of going out to visit our members and their elected and appointed officials and do training for you all in tips and suggestions for success in doing your job as an elected or appointed official for the town. Oh, and by the way, tips for staying out of harm's way from a liability standpoint. We have others in the organization that do trainings for your staff and your operations folks, just to give you a sense of that. For example, if your public works folks want to get their flagger certification for flagging construction zones, they can sign up for a CIRSA class to do that. We have in-person classes, online classes. For you all as elected appointed officials, we have on our website at www.cirsa.org a page dedicated to resources for you all as elected appointed officials that touches on topics that I hope are of interest to you. So that's what we do, and so that's what my presentation is about. It's a presentation for you all as elected appointed officials on ethics, liability, and best practices. A couple of housekeeping matters. There are copies of my slides at your places. I know that typeface is kind of small on those, so if you can still read those, congratulations. But if you'd like a bigger version, staff will email you the electronic file for those PowerPoint slides as well, and you can have those as a resource. And I hope you find the slides helpful to you. I also put at your places a couple of other handouts on some topics that I'm going to hit on as we go through the presentation. One's on email. We're going to talk about email a little bit. We're going to talk about ethics, because whether you knew it or not, when you became an elected or appointed official, you became subject to Colorado state statutes governing ethical conduct by local government officials. So there's a handout on that as well. And then the last one applies more to the handout. It's about quasi-judicial. We'll talk about what that term means. It applies more to the planning commission and the town board, but I think it's good for everyone in the organization to get a little bit of basic familiarity with what a quasi-judicial proceeding is and what that means, because there are different rules that apply. Okay, that's a fancy word that just means judge-like, and it comes into play when you all, as planning commissioners or town board members, are making decisions that affect people's property rights. So we'll break that down a little bit more. Nathan is going to run the slides for me, so I'll try to remember to say next slide as we move through the materials. I do welcome questions at any point throughout my presentation, so if you have a question, please just grab my attention to do the best that we can to make sure that questions are audible. I do have, did I lose it already? Okay, phew, I didn't lose it. Nathan's got a microphone that we can use, so folks who are online, I'll try to remember to repeat the question, but also if you're having difficulty hearing a person who's got a question or comment, please try to grab Nate's attention. We'll make sure that everyone is able to participate in the discussion this evening. So with that, let's dig right in. I'm going to cover a couple topics: the role of being a public official. For how many of you is this your first foray into public service at the local government level as an elected or appointed official? A couple? So thank you very much for stepping up to serve your community, right? And those of you that have a couple of terms under your belt, thank you for continuing your service right to the town of Green Mountain Falls. Who's got a couple terms? And what's that, 4 to 8 years? 2 terms? 2 on planning commission, so that's about 6 years, getting 6, right around there, somewhere in that range. All right, anybody got more than 34 years experience as a local government elected or appointed official? That's my record. That's my, just so you know. By the way, I asked that question down in a statutory town. That's what you are, a statutory town. I'll explain what that means in a second. And I was down in Southwest Colorado, and I asked that question. I said, talking to the elected officials, who's got a couple of terms? And the mayor said, well, I got 34 years on the board. And the first thing that jumped in my mind was, is it term limits? No. In a statutory town, right, the office of mayor and the office of trustee are different. So here's how you do it. You know, for anyone who's interested, you run for mayor and then trustee, mayor, trustee, and eventually you get your 34 years or more of service to the town of Green Mountain Falls. And I assure you, the town will appreciate that and love you for your service. So however much time you want to commit to public service, you can do that in that role. Just as a sidelight, particularly for the folks that are new to local government, I mentioned statutory town, and maybe thinking, what does that mean? So let's break that down just to give you a little bit of background on municipalities in Colorado. So we've got 3 types of municipalities in Colorado. You've probably heard of the concept of home rule, right? But we have home rule municipalities, statutory municipalities, and we've got one other oddball called the Territorial Charter municipality. Statutory municipalities like Green Mountain Falls, what that really means is you get the power and authority that's given to you by the state legislature, just to keep it simple. So the question comes up, can we do this? Do we have authority to do this? Can we regulate in this area? The answer lies in the powers that are given to you by the state legislature. They write the rules of the road for you. You have the powers that they give you expressly by statute, or the powers that are necessarily implied in those statutes. And that's the board, right, on which you play the game. As a home rule municipality, you derive power directly from the Constitution, and you get to write a charter. And a home rule charter is kind of like a local constitution that gives you more power in determining your own rules of the game in matters of local concern. Not all matters are of local concern. Some matters are of purely statewide concern, which means you have to do just what statutory municipalities do, and you have to follow the state rules. There are matters of local concern, primarily having to do with things like how you organize your government, maybe some more leeway in matters of financing, maybe a little more control over procedures involving land use and so on. If you're a home rule, you get to write different rules in matters of local concern. And then in the middle is this area of matters that are mixed statewide and local concern. And there it's a question of can the local rules and the state rules coexist? So that's a little primer on municipal law. Most of the larger municipalities in the state of Colorado are home rule, but the largest by number is still statutory towns. And that's the small to mid-small communities around the state. I mentioned that there's one type of municipality called the Territorial Charter City. The interesting thing about them is municipalities are corporations, by the way, right? And particularly for the town board members, you're like the board of directors of that corporation. The Territorial Charter City is simply a municipality in Colorado that became a municipality before Colorado became a state. And there's only one of those left. Does anybody happen to know, want to guess at the name of that one? Oh, Greg might. Georgetown. Yeah, they became, town of Georgetown before Colorado became a state, and they decided never to reorganize afterwards. And they still use quaint, old-timey Western names. I think what we would call the mayor here, I think they call the police judge, right? And I think when you get a speeding ticket up there, they still pull you over on a horse. Now, but it's kind of, it's interesting, just an interesting historical sideline about organizational structure. We're going to talk more to pivot to what we're talking about. So we're going to talk about the role of being a public official, elected or appointed. We're going to talk about the town's organizational structure and liability. We'll talk about open meetings, transparency. That is a huge expectation, right, in the governmental realm, right? Being a public servant is way different than the private sector in terms of expectations and rules regarding how you do business on behalf of the town. So we'll talk about that. We'll talk about ethical obligations and personal conduct, and some tips to staying out of harm's way there. And then we'll talk about due process requirements. I have to make this disclaimer, though I am an attorney, this is not an attorney-client session, okay? I'll still, and I do encourage questions, and go ahead and ask me whatever questions you want. I'm happy to give you a couple of thoughts from CIRSA's risk management perspective, but this is not an attorney-client advice session. I do have a good radar. By way of background, before I joined CIRSA 3 years ago, I was a city and town attorney for about 25 years. Went to a lot of board meetings and a lot of board committee meetings. So I got a pretty good radar for what I consider the live one. Okay, so ask me any question you want. Sometimes, maybe somebody asks, Sam, I've got a question. What if another member of my board does this? And everyone's eyes widen. Oh, this is going to be exciting. My radar is going off, telling me that that's the burning question of the day here in Green Mountain Falls. And if it's a legal question, then I'm going to tell you, you need to get in touch with the town attorney and rely on their advice. I could still give you some suggestions, but if it's a legal matter for which you need advice, rely on your town attorney. If it's a matter for which you need staff support, then you're going to rely on Becky and her team to help you out in that area. Okay. All right. Let's go ahead and dig into my first suggestion for you. Next slide. All right. May not sound like much of a risk management. No matter how long you've been in local government, whether you're brand new or been around a while, I think it's good to touch on this concept. When you become a local government official, your role and relationship to this community changes dramatically. May not seem like it all the time, but it does, right? Because you're no longer just a citizen of Green Mountain Falls. You're now a government official, and that really is a 24/7 undertaking. I'm not saying don't have a personal life, please do, and please enjoy it, right? But recognize that now that you're a local government official, right, particularly when you're dealing with your citizens and your constituents on matters involving town business, right, wherever it occurs, they will always perceive you to be a government official on behalf of this organization, right? And you may tell them over and over again, this is my personal opinion, but the ones that are in the know, they still know, right, that you're on the planning commission or the town board or one of the committees, right? They will always perceive you to be talking as a representative. And, as they should, your words, your deeds, right? Your actions matter as government officials. They have impact. They have meaning. If they're a little off the dartboard, they can leave a bad residue, right, for you or for the organization. And in the worst scenario, they can potentially have legal consequences. So just keep that in mind, right? The 24/7 concept is, sometimes, maybe not so much for the committee members, but trustees, elected officials tend to be on the receiving end of this more. You may get the phone call at 8, 9 o'clock at night where they're going to bump into you over at, is it the Dancing Bear?
Black Bear.
Black Bear? Bumping you over at the Black Bear, and they're going to ask you a question about town business, right? And they're going to be, their perception is, hey, this is a government official speaking to me about that. Okay, so keep that in mind. Recognize also you're no longer an outsider to town government. You're now all insiders. You're kind of the ultimate insiders. And the way that has meaning for you in terms of risk is once you're on the inside of the organization, the town's ways of doing things and the town's rules, ordinances, the bylaws for your committee, right, or commission, those now apply to you and they stick to you. And part of your commitment is that you agree to follow those rules that govern the way we do things as a government official. Also, whatever your interest was that led you to public service, right? Now, with respect to whatever area you're in, whatever board or commission you bring expertise to for that particular subject matter, you're now kind of a representative or an ambassador for this organization with respect to that area, right? So keep that in mind. Sometimes there'll be something on your agenda that isn't, particularly your favorite topic. Maybe you got other things that you would like to see the board spend its energy on, but when you sign up for one of those groups, you really sign up to be a good representative, right? On behalf of all your constituents with respect to all of the issues that come in front of your board or commission. So stay engaged, stay prepared and ready to address all the issues that come in front of you. Yes.
I just want to make a comment here. One thing to remember, especially if you don't agree with the vote or the reason for the vote, once the vote is cast, everyone is on board for that vote. We can't go out bad mouthing it afterwards. All are one after the vote.
Thank you. Next slide. The trustees, who are trustees again, or soon to be trustees, trustee-elects? Okay. So pretty soon you're going to take an oath, or you've already taken an oath. If you're on a board or commission, maybe it wasn't as formal, you didn't raise your right hand and say, I swear to uphold the Constitution and laws of the state of Colorado and the ordinances of the town of Green Mountain Falls, but you all really did. That's part and parcel of being a public servant. Just remember that that kind of oath, right, has certain commitments embedded in it. Those commitments have meaning for you ethically, morally, legally, right? I think every oath of office, whether you're elected or appointed, involves at least these commitments, right? A commitment to respect and stay within your assigned roles in the town's organizational structure. We're going to talk in a little bit about it. Everybody in the organization has a job description. Everybody has a lane, right, that they're in to help us move this organization forward. You also made a commitment to lawful conduct, as I mentioned a minute ago. Those things stick to you, right? So part of that commitment is to follow the town's rules, procedures, and policies in approaching how you make decisions. And then you also made a commitment to ethical practices. Next slide. For the appointed and elected officials in particular, I think part of the job description is delivering good governance, right? At that leadership level. Oh, by the way, who likes process? You like process? You will. You will. You will. One of the products that we deliver at local government level is process, right? Process is a product in and of itself. It's a substantive product of local government. We provide a forum, right, and a venue for people to come and talk to us as local government officials, to tell us their interests, their wants and needs, and then you're all uniquely positioned as local government leaders to talk at that governance level about, well, how do we put governmental resources on these wants and the needs of the community? How do we prioritize things? And you all have a valuable role to play in that, whether you're on the board and a final decision maker, or you're on one of the advisory boards and you're providing recommendations. So recognize the process, that public-facing process. One of the expectations is that you deliver the product of good governance. Now, in my many years of doing this, I think by and large that delivering good governance is based both practically and legally on just committing yourself to a few core civics principles that I've listed on the left-hand side of the slide. If you commit to the civics principles in bold, then by and large, the legal issues that are attached to them are going to take care of themselves. So, for example, commit yourself to openness and transparency. And we're going to have few, if any, disputes, controversies, watershed claims over compliance with Colorado's open meetings law or open records laws. As an example of that commitment to transparency, who uses email to do their job as an elected or appointed official? We do. And do we recognize that the emails that we send or receive wearing our hat as a government official, to do our job as a government official, by and large, are public records. That anyone can go to the clerk's office and say, I'd like to see the emails of the planning commissioners on this particular topic. Now, you don't have to turn over your personal emails, but if it's an email, right, that concerns the performance of your duties or functions as a local government official, or concerns the expenditure of public funds, then that email is likely a public record. There are a few exceptions where documents can be withheld from disclosure, but there are just a few exceptions because the presumptive rule is that the correspondence of elected and appointed officials wearing their governmental hat are a matter of public records. So I'll have a couple more tips on that, practical tips on good use of email in a little bit. Commit yourself to fundamental fairness, and you won't face any claim or risk around the issue if someone says, you violated my due process rights. Right? It doesn't come up all that often, and probably comes up very rarely for the advisory boards, but for the planning commission and town board, sometimes there'll be questions. Have we given proper notice? Or maybe we're in the middle of a public hearing. What do we do with this new information? Has everyone seen this new information? The applicant or the objectors or the proponents of this particular clause are saying that something procedurally is not correct. We want to make sure we slow down, right, get appropriate and err on the side of making sure that our process is fair and comports with legal requirements. Commit yourself to being predictable and even-handed, right? Nothing can undermine faith and trust in government more, in my estimation, than a vibe that the government is acting on a whim, or that rules seem to be changing on the fly, though the written rules never change, right? It's particularly important to the business community, but it's true for everyone, right? If you have someone that comes in to the board or planning commission for, I don't know, a fence permit, and they say, well, it was a straightforward process. The application process was very simple. The requirements for the application I understood. When I got to the meeting, the criteria were very understandable, predictable, and I got an approval, no problem. Somebody else in the same situation, what if they're saying to themselves, well, that's weird, because I feel like they asked for a bunch of things that weren't listed on the application requirements. And I feel like when I got to the meeting, they took this novel and unprecedented interpretation of their rules, in view of turning me down. Does that sound like a good place to be from a risk standpoint? Not so much, right? And also, it can lead to the legal problems. The claims that we see in this area are equal protection claims, where someone says, well, I'm similarly situated to someone else, but I was treated differently. That's the equal protection claim. The fancy word, a certiorari claim, is simply what I'm trying to encapsulate here. And that's a claim that whatever decision the local government made was arbitrary, was not founded, right, in any competent evidence, and was basically a made-up decision. You don't want to be in that position. My last bullet here may not sound like much of a predictor of risk, but I think it's a huge predictor of risk. That is, commit yourself to civility and mutuality of respect. Mutual respect with each other as fellow elected and appointed officials, with staff that you interact with, and with all the citizens and constituents that come in front of you. Okay? Because I know, and I get it, it's not an easy job. I hope this isn't true every meeting, but you're going to have some meetings where there's kind of a hot topic on the agenda, or beyond that, something that's very controversial. And there are a lot of different opinions of what you ought to do, both internally and by maybe citizens who come to your meeting and give you input, right? And maybe it gets to the point where it's such a tough issue and an emotional issue, an important issue for the community, that the first person who stands up during public comment says, board, right, or committee, I want you to do this. And the next person who stands up says, well, I want you to do exactly the opposite. Right? Oh yeah, this is one of those jobs where I don't get to make 100% of the people happy 100% of the time. That's okay. That's okay, right? If they go home from that meeting, here's a great place where you want to land. Even if they go home from that meeting and say, you know what, I disagree with the recommendation that they made or the decision that they made, but you know what, I feel like it was a good process. I feel like I was heard, right? And I feel like I was respected. What an awesome place to be in terms of faith and trust in government. And when that's the outcome, the legal issues are going to slide away. Right? The predictor of risk is that sometimes somebody goes home with the opposite belief, and they'll be thinking to themselves, well, gee, not only do I disagree with what they decided, but I feel like they already made the decision before they got there. That their request for public comment or public input was meaningless because they already had their minds made up. Or that there was something weird going on with the procedure. Or that they didn't listen to people, and worse yet, I feel like I wasn't respected during that conversation. Those are the people who sometimes can get so mad and say, and I'm so mad, I'm going to try and find out if I've got some way to legally challenge what they did. Okay? So those are important concepts to keep in mind. If you commit yourself to those, I think you'll be in a good spot. All right.
Sam,
Next
can I make
one.
one comment on
Yes.
this?
Um,
Nothing to lose. One other thing that I would really like to say, and people that have already been on the board know, if you don't feel like you've had enough time, because there are a number of times that prior to getting the board packet, there are issues that nobody seems to know anything about. Don't feel pressured to make a decision that night. If you feel like you need to have more research and you can have more time, don't worry about tabling an item, regardless of everybody screaming at you, that why didn't you make this decision right now? Because, you know, if you need time to research, you need time to research.
Yeah, or to get more staff support, or in fairness to each other, to give each of your fellow colleagues and yourself time to let an issue ferment a little bit, give you more time to prepare for a discussion. I know sometimes it can be frustrating from a citizen's perspective, that it may take longer for a process to arrive at a decision. But what are we in local government, at all levels of government? We're a deliberative process, right? Sometimes people say to a fault, but remember, we're trying to make policy and make decisions that will stand the test of time. It's true that some successor body may revisit a decision that you made, but in general, our objective is to engage in long-range planning, large, permanent types of undertakings for the town, projects, investments, things like that. So one of your, as you mentioned, I think one of your strengths and prerogatives that you should always feel comfortable using if you need it is take the time you need and get the information that you need as decision makers and as advisory bodies to enable you, right, to make a decision that you're comfortable with. Okay, so as you mentioned, a continuance comes up with public comment because you may be more often than perhaps other times, someone from public comment brings you an issue that night. Right? And that would necessarily must mean this probably isn't the best time to take that up and start giving direction and action. Maybe let's put it on a future agenda. Yes, sir.
For public comment, we have a set of, say, standards for people who are commenting, for example, someone.
Okay, I can hear myself now. For public comment, we have a set of standards. For example, say someone gets up and starts using profanity.
Mm-hmm.
Are there already a set of established standards that we can rely on to say, hey, timeout? I can bang the gavel and say, we need to have you address us without profanity, yada, yada. Are there already a set of standards like that established?
So there are, and we'll talk in a little bit more about public comment periods. So I'm the one, and we're the one that we get to deal with all the scorched earth claims. So there's some pretty difficult legal issues around this. But as a body, I think you must use, and you can expect civilities, but you have kind of limited in the tools because you want to make sure you don't, inadvertently step into a civil rights risk. But you can do certain things, and group habits rub off on 99% of the people, right? So if we're using civility, and if there's a set of public comments that are particularly abrasive, if we just remind everyone, please, be professional, be courteous, be civil, direct your comments to the board. 99% of the people will get that and be on board with that. Some tools that I've seen, if you're having difficulty around that, is maybe you can have a poster that has guidelines for public engagement, be respectful, be courteous, those kinds of
We do
things.
have protocols, and one particular one is, we don't engage and we don't answer anything, we just sit and listen. But we do have guidelines for public comment.
Yeah, yeah. If you've got a public commenter who's I call it they're coming in hot, that probably not much you're going to say in the moment that's going to make them any cooler, right? So if you have that traditional public comment period where you say, we'll now hear from people who don't have items on the agenda. You've got a couple of minutes, whatever it is, 3 minutes or something like that is your guideline. Please address your comments to us. If they, 20 seconds into it, you go, well, this isn't going to go well because I stand up during my public comment period and say, well, you're all crooks and liars and I hate local government and bleep, 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 bleep. What are we going to do, right? Probably engage in the right area. So we just let them run their remaining 2.5 minutes off and say thank you, and we just call the next person. Right. Greg, you've been around this issue a while. Any thoughts? Not to put you on the spot. Suggestions?
The best thing that I will give a training to the trustees in May, and the one thing I will tell them is that if they are addressed with a statement, acknowledge the statement and say thank you. If they're addressed with a question, if you know the answer, give it. If it needs to be researched, refer it to staff and move on, and tell the person when and how they will get a response. Goes back to your transparency and openness. That's how, that is, any trustee that comes to the training that I will do in May will hear that exact thing.
Yeah. Yeah, it is. If you're the presiding officer or the chair, one of the other things you can do is lay the groundwork for the expectation around that public comment is for comment. It's not, so whatever that looks like in terms of the appropriate tone and temperament. I've seen some scripts that say, this is a time for public comment period. This is your opportunity to address the committee or board. Please keep your comments brief. The board typically does not answer questions during the public comment period, but staff and members are listening. And if a question does come up, we may provide some feedback at the end of the public comment period. That allows you to get through all the public comment. And then if it's a question that came up and it's for Becky, the presiding officer could say, Becky, but could you address the question that came up about the status of the road closure, right? Becky, there was a question about our rules for fences. Could you provide some feedback to the citizen who asked so that they know where they need to go? So, did you have those comments on that, or you're just getting ready with the mic? Getting ready. All right. Okay. So as I mentioned, CIRSA, we handle the liability issues for you. So I need to cover some of the hardball topics here. But my suggestion too is to commit to supporting the town's structure. I'm first going to talk about the liability aspects of that. Okay. As I mentioned earlier, right, this part of the job is a commitment to understand and stay within the job description. Everyone within a municipal organization has a job description, whether they're an elected official, an appointed official, an employee like Nate and Becky, or even a volunteer, right? So it's important that everyone understand their job descriptions, stay within the parameters of their job description, to borrow from I think it's an insurance commercial, to stay in their lane with respect to their duties so that the organization functions at a high level, right? And so that we avoid the risks of liability, even the potential for personal liability. Let me explain what I mean by that, because CIRSA is an important part of this protection that you have. So I hope that for the new board members and new appointees that your first question to staff or your town attorney was not, can I get sued in this job as a government official? But the answer is yes, right? And we read about it. It doesn't happen all the time, less so with advisory boards, but it can happen. So I hope your second question was, well, if the answer to that is yes, don't I have some protection? Well, yes, you do. And the answer, so let me explain how that works. Under Colorado law, and this is a very, by the way, I'll take questions if you want. This is a very broad brush, 40,000 foot level summary of these concepts. But under Colorado law, we have this statute called the Colorado Governmental Immunity Act. And what it basically says is this, is that the town, and by extension, the town's insurance company, will defend you and will pay judgments that are entered against you as a public official for acts or omissions as a public official. That sounds good, right? Well, there's always a catch. So long as you are acting within the scope of your employment, job duties, right? So long as you're acting within the scope of your employment and not acting in a willful and wanton manner. So two interesting phrases there. Scope of employment may sound a little odd to an elected or appointed official because you're thinking, well, I'm not a town employee like Nate or Becky. But the takeaway for you all is that's just simply the phrase that's used in the statute. It just means that on a universal lens, what are my job duties? What is the scope of the authority that I have? So I need to stay within my scope of employment in that respect, okay? The other wonky phrase there is willful and wanton conduct. You're protected as long as you are not engaging in willful and wanton conduct. That's simply this. It's conduct that's intentionally undertaken, that's designed to injure someone's protected legal rights, and that's undertaken with reckless disregard for what their rights are. I got an even simpler phrase for it. I just call it bad stuff. Stay away from bad stuff. We know what it is. We're going to stay far away from it, right? And these kinds of claims are few and far between, right? In Colorado, and at CIRSA, only occasionally, less than once in a blue moon, do we get lawsuits that make allegations of willful and wanton conduct against local government officials. But it happens sometimes, doesn't happen that often because you are all committed, right? And whatever organization you're at, and for all local government officials statewide, we all take our commitment seriously. And we commit ourselves to staying away from bad stuff. But here's the most common fact pattern that I see, just to give you a sense of where this risk might lie. It's usually a government official acting individually, misperceiving that they've got some governmental authority that they don't have, right? Throwing on that cloak of governmental authority and starting to do bad things to people for the wrong reasons. Sometimes it involves conscripting a staff member into their cause who also is not thinking straight on the issue and doing things like, well, you know, we ought to red tag that person's building. You know, maybe trying to use the force of government to go after business competitors or political enemies or someone that you just don't like. Does that sound like bad stuff? Yeah, and it is, right? The double whammy, and I apologize for sounding like the Grim Reaper, the double whammy on this is that if you are engaged in willful and wanton conduct, and that's the finding in the liability claim, then your insurance protection falls away as well, because the town has no obligation to indemnify you or pay judgments against you for willful and wanton conduct. That includes criminal conduct as well. It's self-evident that the town wouldn't have an obligation to protect an individual for their own criminal misconduct or fraud or malicious conduct like that. And our insurance that we provide to protect you has similar exclusions to coverage. So to drill down just one layer deeper, some people will say, well, that concerns me because what if I'm on the receiving end of allegations that aren't true? Someone alleges that I committed willful and wanton conduct. Am I still protected? So the way that really works in 99.99% of cases, unless our elected or appointed official says, yeah, I did it. And they say, no, I didn't do it. And these are incorrect allegations. Then what we do is we defend those officials under a reservation of rights. We say, you're defended, we're assigning an attorney to defend you, but just recognize if we end up this case actually ends up going all the way through the litigation process, and if a judge or jury finds that the conduct was willful and wanton, then we reserve our right to not pay the judgment, but we will defend you in the meantime. So, all right. So I know that's a little more, sorry about that. Let me end on a silver lining note. On the other hand, don't let the fear of liability drive your decision making. Right? If we know that we're making the right decision for the right reasons through a fair and defensible process, you're going to be just fine. as an organization and as the individuals who made the decision. And that's what insurance is for, to protect you in those situations. So, by the way, I looked at your claims run, and you have very few claims for this over the last 5 years or so, you know? So it doesn't happen all that often. I just want to explain what those protections are. Any questions about that stuff? Good, all right. Let's move on. Next slide. This all probably led to the question, well, what's my job description, right? So just a little bit more here at a 40,000-foot level. We operate here as a statutory board manager form of government. Under that structure, like all municipal organizations, there's kind of a separation of powers, right? The board of trustees is akin to the board of directors. Municipalities are corporations. They're the governing body by state statute and your own ordinances. It says that the board of trustees holds the legislative, the policy-making power, and the corporate authority of the corporation as a whole, right? So they're focused on policy and governance, okay? Boards, committees, and commissions, they serve an advisory role. The planning commission handles some quasi-judicial hearings, right? But in that role, the advisory groups help the board make policy. And I know that they also have input on things like master planning for fire mitigation and for parks and trails, and also help implementation of plans in helping decide once the board has approved a budget, they'll help implement a plan or a project. So those are advisory functions. And then your manager is akin to the private sector CEO type of role, chief executive officer, right? And if you want to drill down and read where all that comes from, I've given you some citations there that you can look at. If you're on advisory board, I do recommend that if you haven't done so already, you want to read a copy of ordinance number 2020-03. That's kind of the roadmap, the charter, the organizational document that sets the framework for the job descriptions and responsibilities of advisory board members. Okay, next slide. All right, so for us as elected and appointed officials, like this little hierarchy on the left-hand side of the slide, where then do advisory boards and governing bodies spend their energy and efforts on this hierarchy? Right? You're all at those first two tiers. As I mentioned with, it's the governing body and the advisory boards are the ones with the longer time horizons who help determine long-term master planning, help determine the inputs into the annual budget, have in view the long-range interest of the community. Where do we want to be in 3, 5, 10 years? For the fire group and the parks group, your job description in the ordinance is recommend a master plan in those areas, long-term visioning. So you can see that with your focus on those two top tiers, right, your job description is not frontline supervision and management of staff or handling day-to-day operations. In fact, it would kind of be disappointing if the outcome of your tenure was, well, we got bogged down in reacting to things that came up meeting by meeting, right? If that's what's happening, you're not setting aside enough time to do the things that you're most uniquely qualified and appointed or elected to focus your energy on. And that's the governance and the ownership aspects. Who owns our corporation? Citizens. Yeah. Who's most uniquely qualified from a policy-making standpoint and a planning standpoint to help determine the wants and needs of our owners? The governing body and the advisory boards, who are the policy-making engine. And then once you adopt policies and priorities and things like that, who's going to be responsible for carrying that stuff out? Becky's got her hand raised. And her staff, right? Okay, so I hope that helps organize things for you. Next slide. As I mentioned, ordinance number 2003 reviews that are applicable to your group, right? Recognize that you act in an advisory role, but never, if you're on one of those advisory groups, never ever approach the job by saying, well, it's only a recommendation. It is a critically important part of the policymaking process. I know sometimes things can get a little askew, and I've been in meetings where sometimes there's a little bit of frustration in the dynamics in an advisory board saying, well, you know what, let's just move this on because it doesn't matter what we say because the higher ups are going to make the decision. So we'll just throw it to them or we'll punt it to them or it's their problem, right? In Colorado and municipal forms of government, when we affirmatively decide to create an advisory board, they have a critical role in helping. And they may not show up at all the meetings, but when citizens, when they show up at the trustees meeting, right, and they say, well, gee, this is something, how did we get to this point, right? As an organization, our governing body is going to say, well, we started this process long ago with important and valuable study and input from our advisors, right? So everyone's a champion of that structure. So it's true, yes, you don't, as an advisory board, make the final decision. That's for the board of trustees, but that advisory role is critically important, right? Recognize that that ordinance also says that boards, committees, and commissions don't have authority to act on behalf of the town. So, for example, they don't have authority to negotiate contracts, right, or direct the expenditure of funds. To the extent you have some input on funding, it's meeting as a group, right, and helping develop suggested direction for funding priorities and things like that. Okay. Any questions around that? Anyone want to add anything? Yes.
Sorry. One of the things that happens, and it's happened I prefer in the last few years, is when the board of trustees asks the question, how did we get to this point? So committees, remember, it has to go through the proper channels because we can't have a potential legal issue facing us and we don't even know anything about it.
Yeah. Everybody's got different approaches on these issues, but it ought to be in that ordinance, by the way, there's a couple words that jumped out at me a couple times in reading it, I think was the concept of coordination. Whatever that looks like to you as an organization, there ought to be this synergy in developing priorities and work plans and flow of information, all in a collaborative effort. Some tools and techniques that I've seen from other members is between the governing body and the boards and committees, they'll exchange work plans, they'll have periodic updates, they'll maybe have a joint meeting with each other at certain intervals to check in, see how things are going, make sure energy is focused in the right place so that there are no surprises running either direction, right? In that regard. So anybody else have further questions or thoughts? Yes.
The scenario you just described, would that be a public situation?
The joint meeting?
Yes.
Yes.
When would meetings not be public? When is that okay?
Few and far between, and we're going to pivot to that in about one more slide. We'll talk about that. Yeah. So perfect. Thank you. Yeah. Any other thoughts? Questions? Okay, let's go to the next slide. So here's a couple practical tips on staying out of harm's way. These suggestions aren't so much going directly to liability issues, but I guess in a worst case scenario, they could. But here are just some practical suggestions to support the organizational structure and avoid any problems around the concepts of role discipline or what's my scope of employment. A couple of things here. So understand the job description, look at the structural documents. It's important that we not only understand what our job description is with respect to our own board, commission, or committee, but also what other people's jobs are, right? Because once we understand, well, that's the clerk's job, then we understand it's not our job, right? And respecting that does two things. First, well, you can be, not my job. You're unburdened from that when a constituent says, well, I didn't, my building permit didn't get approved. What are you going to do about it? Not my job. That's been delegated to our building official, that kind of thing. But it also, from a standpoint, protection, because we can also say, look, as long as we're staying within our lane, right, then if we ever got some assertion that somebody should have been involved or should have done something, we could say, no, it's clear from our organizational structure that that's not the purview of a board or commission member, okay? Recognize that your role, what you signed up for, was to be a participant on a team. Boards, committees, and commissions, they work as a team, right? Each of us is but one contributing part of a 5-member body, right? At the end of the day, it's one voice. We each contribute our individual voice, but the board speaks with one voice, right? So recognize that elected officials primarily do their, and appointed officials primarily do their work as a body and exercise responsibilities, and very importantly, take action only as a body that meets, right, at town hall or by Zoom, right, and takes action collectively. Very helpful from a risk management standpoint, because in my world, very hard for someone to say, well, trustees, I'm gonna sue you and only you for that decision the board made last night. That sounds pretty weird. And it is. It's very hard to legally pursue a theory of liability against one individual simply for a proper vote that they made as part of a body. You know, that person's got a beef. They got a beef with the whole board as a board or the town as a town. Okay, so all this in practical terms means that we ought to be thinking in terms of we, not I. Going back to my earlier concept of individuals stepping out a little bit. If there's an urge to say something like, well, I didn't like that, or you do what you want, I'm going to do this, that's a red flag, right? So do you all, on the trustees, do you have maybe do this on committees too, do you have a point in the meeting where you go kind of around the table and you say, anybody have any reports? Okay, so this isn't so much a liability concern, but a lot of municipalities do that, and the presiding officer will say, anybody got any reports? I say, yeah, Mayor, I got something to report. Since our last meeting, I did this. If everyone else says, you did what? Right? That may not be a liability issue as respects any third party, but it does, I think, suggest a very critical component of board dynamics, right? If that's the reaction, you have to ask yourself as a board or commission, have we engaged in some self-reflection and discussion internally about what are our norms and expectations for how we act individually outside of meetings on behalf of this organization? And I mention it because I want people to be supported. I don't want them to come back to a meeting and face that dynamic of you did what, but it requires some investment, right? Because a lot of times people do volunteer to do something outside of the meeting, right? But if we ask, we ask the mayor pro tem, and we're on the board of trustees, Mayor, why don't you go out and talk to the county for us, right? If she comes back and she says, well, I did what you asked, I went and talked to the county, and the reaction is, you said what? Right? Then we haven't done our homework as a board in agreeing upon what's our position, what's our message. Or in the tougher case, sometimes somebody wants to volunteer. Well, I'll go out and do that. Are we self-policing enough to say, if someone says that and it's clearly not a role for that member, do we say, no, we shouldn't be doing that. That's for staff. All these dynamics are very important to functioning at a high level, kind of firing on all cylinders as an organization. Okay, all right. Next slide. Oh, my last bullet, sorry, is sometimes after you do a project, you get the project in the budget, you're implementing a project, and you got like a field day, and you're all individually helping with the project in the field as a volunteer. That's not what I'm talking about here. I'm talking about your group role as policymakers or advisory board members. Okay, that makes sense? All right, next slide. This idea of organizational structure is very important in your relationship to employees and handling administrative matters. So in that organizational structure that we have, recognize the town board hires and supervises just a few people, the town manager, the town attorney. Do you have a municipal court? The judge? What's that?
We have capability.
Capability, okay.
We do have municipal court. It's rarely used.
Rarely used, okay, but it's the town board as the town board that's the supervisor of the manager and the attorney. and maybe one or two others. But other than that, elected and appointed officials are not employee supervisors, right? And so we need to make sure we understand that principle, right? And make sure that we do not get inappropriately or individually involved in personnel matters that are not part of our job, okay? It happens every once in a while. Even comes up in claims, and sometimes I'll have a claim where an elected appointed official gets ensnared in a personnel matter because they got too deep into it. And maybe the claimant is saying, well, part of my claim involves some comments that were made to me by that elected appointed official. So now I'm off to the races with our defense attorneys, and we got to interview that elected or appointed official, say, what's your perspective? What happened? I've never had an elected appointed official that got ensnared in an employment dispute, had their deposition taken, ever come back to me afterwards and say, that was a lot of fun, let's do it again. Okay? So recognize, you know, as citizen volunteers, helping the community and the broad community wants and desires, recognize that you don't have to worry about those things. You don't need to take on that role. That's what you want your full-time paid professional staff to deal with. And by the way, the professional staff that deals with HR matters, they love taking all that risk, right? Yeah. So let them take that risk with the proper resources and advice for employment matters that have a lot of recognize that one of the things that CIRSA does, if our members want it, it's there if they want it. If they don't want it, they don't have to use it. But we have some resources to help them make sure that they're appropriately addressing employment matters. But so as I said, I was a city and town attorney for 25 years. I know it happens. Sometimes someone's going to come up to you maybe and say, can I talk to you about my boss? And what are we going to say? I got a suggestion. We love and appreciate our employees, but I, as an elected official or I, as an appointed official, do not get involved, and we as a board don't get involved in personnel matters. I would suggest that you raise this matter with your supervisor or the town manager or whoever is described in your policies as the appropriate person to go to. Okay. Now I know sometimes before you can even get that friendly suggestion out, maybe they blurt something out that's pretty blockbuster, right? You get, well, okay, then I want you to unburden yourself of that. Go to the town manager or the town attorney as appropriate. Say, somebody reported this to me, and then trust that there are systems in place to address those issues, okay? So any questions about that stuff? Same principle applies with administrative issues. I used the building department earlier. Recognize that in all matters of municipal policymaking, at some point the policymaking job is done and then administration of policy takes over, right? Like on development matters, once the planning commission and board have made a decision on a development matter, it then moves to the administrative process for the person to get their building permits. We have to understand that separation. And once it's done at our board, we cannot be involving ourselves in the administrative process. To give you a war story, for example, I had a very contentious development matter where the governing body voted 4-3 to approve a project. The mayor was on the 3 side. And he went to the planning department and said, by the power vested in me as mayor, I'm directing you not to issue building permits. Good idea? Not a good idea. But you can see, particularly if you're doing that individually, you can see how it loops back around to my risk scenario, right? Where you could be putting yourself in the crossfire if you're getting involved in administrative matters that are not part of the job description. All right, next slide. The last piece I want to mention on this is recognize that part of the job is recognition that, as I mentioned, we're all contributing to a single voice, that it's not a 5 boards of 1 or 7 board of trustees. It's right 1 board of 5 or 7 members or whatever it may be. Sometimes this requires us to do a couple things, right? That even though we may have our own particular item that we really want to see the board take up, if 2 other members aren't on board and there's no traction, then we have to be willing to set aside our own personal desires in view of the work plan as identified by the board. We have to accept, as was mentioned in the earlier comment, that our board has spoken, even if we didn't prefer the outcome. You could probably tell your constituents, yeah, I didn't vote for that one, right? But as fiduciaries, you have an obligation not to do things downstream of the decision that attempt to undermine or interfere with the decision that was made. Okay, all right, next slide. Just keep moving. Let's pivot and talk about transparency. Now we're landing on these kinds of concepts. So I think there's a lot to cover in this. Transparency is not a legal word. It's just the buzzword around the expectations. So your citizens expect, and the law requires that we do our job as government officials in a transparent way. I just want to talk about the open meetings law quickly. So there's a lot going on in the Colorado open meetings law, but as elected or appointed officials are all subject to that statute. And it basically says this: whenever 3 or more members of your board meet to discuss public business, that's a meeting that has to be open to the public. Simply means a citizen has a right to observe that discussion. Okay? The additional twist, right, is that if a quorum is going to be present, that means 4 for the Board of Trustees. It's the same number for the rest of you because you're all 3, right? Your quorum is 3. If it's going to be a quorum or you're going to take some kind of action, then you have to post notice in an agenda, and staff takes care of that for you. Okay? So that's it. That sounds easy enough. The takeaway is whenever 3 or more of us are going to discuss public business, it has to be an open meeting. Couple of nuances there. So what if, do we do this? Do we like socialize? Sure, I don't want you to give up your personal life, right? What if the board members after the meeting go out to, what's the local establishment I already used? The Moose? The Moose. What if the board goes after the meeting, go out to the Moose to unwind it a little bit, and all 5 of the board members are there? Is that a violation of the open meetings law? Because I got 5, the entire board gathered together? Yeah, the statute says it does not apply to purely social gatherings, and it doesn't apply to chance gatherings where you just bump into each other. But in either case, right, that only is a safe harbor as long as the discussion of public business does not become the purpose of that gathering. So you got to keep it social. Talk about whatever you want except the Denver Nuggets. Not a good time to talk about that, right? But whatever it is, and every community's got different tolerance on this too, because you may face this. You may go over to the Moose, and the governmental watchdog's going, well, there they are again, over there making public policy in secret, right? So that's a teaching moment for you if you want it to be. Everybody's got different tolerances on this. I really think if you're facing that, you can use that as an opportunity to tell your citizen, look, I assure you that we're just meeting socially, having a drink together. In fact, we'd love to hear from citizens, and we only deal with public business at our meetings. And we post the notices and agendas. We'd love to hear from you. I'd love to have you come. So please rest assured that we're not discussing town business in this gathering.
Listen to us talk about our brand meetings.
Yeah, that kind of stuff. All right. Another twist is that, yes.
Is there a term for that? My background's not for like HIPAA, it's almost like a HIPAA, right? Can't discuss medical stuff with anybody else and keep it private, right? Is there like a term, like a legal term? Sort of like that, term rather than just in terms of meaning.
There's not a one particular word. I put it in quotes at the beginning. I call it the openness requirement of state statute that requires that elected and appointed officials discuss public business only in an open meeting setting.
So, but am I thinking correctly that that's sort of the same sort of protecting the information?
Well, that's the flip side of that we'll talk about in a second. That would be protecting confidential information, which you might get sometimes. Not all that often, but sometimes. Yeah, sometimes. Yeah, sometimes you may come into possession of confidential information. We'll get to that in just a slide or two. All right, the other twist is that a meeting is any kind of gathering in person like we're doing now, virtually, like we're doing now, right? Or by phone or by other electronic means of communication, including email. Right, so the statute expressly applies to electronic communications. So that's why your staff and attorney will tell you, do not use email, right, as a substitute or proxy for discussion of public business. Because if 3 or more members of the body are having discussion of email about public business, then we're triggering the openness requirement. But have we satisfied the openness requirement? No, we haven't posted a notice or agenda. And that email is not open to the public. Right, so that's why your staff will say, do not hit reply all. Do not, even though I just sent you all the packet and all 5 of you are on the email, now that you got the packet, don't start sending emails to the group with your comments on the agenda items or your convincing argument by email as to why your members ought to vote yes or no, because you're now having a discussion of public business, right? So
Sometimes people will try to trip you up because they will send an email to everyone. And 1, you don't respond, but 2, then they'll get mad at you for not responding. So, yeah.
yeah. All right, next slide. So one of my handouts is about email. It just further explains how those rules apply to you as elected or appointed officials with some tips for suggested do's and don'ts. So I think the term they use is a Luddite. That's a person who hates technology. So I'm not trying to be a Luddite here, okay? But I am saying that for elected and appointed officials in Colorado, have to understand how these principles apply to your use of electronic communications. Email can be a good tool for some things to do your job as elected officials, but not the discussion of the substance or merits of public policy issues that are pending in front of your board. So our state legislature, the first bullet there, you can get that link, is an article that I wrote about some recent state legislation that helped us clarify that there are certain categories of emails that aren't going to trigger this openness requirement, but it's things like simply an email about scheduling and availability. Or maybe it's just an FYI. Maybe the mayor sends to the rest of the board, hey, FYI, we've got a discussion coming up about changes to our development code. Here's an interesting news article about blank. Well, you can send out that FYI as long as, right, it doesn't morph into a discussion. So FYI, scheduling and availability. If one of you responds to a constituent and just copies your fellow board members, that's okay. Because you may not know whether they got the same email or not. You can let them know that you responded, right? And you can also just pose a question by email. Maybe you read the packet and you say, you've got an idea of a question that you jotted down on your copy of the packet, and you send to Becky, hey, Becky, for that item that's coming up on Tuesday, could you be prepared to address this question? And you copy the rest of your board. None of those trigger the openness requirement, but you can see the common thread in all those, what's not going on. In all of those emails, there's not a discussion among the members, right, of the agenda item or the matter of public business that's pending in front of you, okay? Who's active on social media?
Personally, yeah.
Does anybody use social media to do your job as an elected or appointed official?
We would have a policy about that.
Well, forwarding information. For example, town will post something,
Yeah.
I'll go ahead and repost to the more of a social site.
Okay.
Largely historical information.
Okay. So there's some risk around social media. Just a couple of things to put on your radar. I suppose if 3 or more of you decided that you're going to use social media to discuss public business, like somebody put a comment out there in a thread about the meeting, and then you saw that your fellow board members started commenting and you're writing comments to each other now, same principle applies, right? So social media is, as you suggest, is probably a good tool for lighthearted things, positive things. Not a great place for adjudicating the lofty issues of the day, and particularly not the controversial issues of the day. That article that we wrote there that you can link talks more about risks around social media for elected or appointed officials. Don't want to cover that too much because it sounds like it's not really a tool that you use that much in this arena, okay? We talked about correspondence. Next slide. Some other transparency pieces, use your agenda for your meeting as a guide to how you're going to spend your energy that evening. There is a risk component to this. The statute says that we need to post specific agenda information where possible. So the meeting notice that we put out there on the website and we post at Town Hall is setting the table for how we're going to spend our energy that evening. Stay focused on that. Be wary of adding things to the agenda. My takeaway on that is just approach it as the empty chair concept. Right, and I know sometimes it's just inadvertent. Sometimes we get to a meeting and we think, oh, darn it, I meant to. Chair, I'd like to add something to the agenda. Well, think about this. Is there a chair out there that would be empty, that's empty, that would have been filled had someone known we were going to talk about that issue tonight, right? And if so, then we say, okay, wait a second, let's slow down. We weren't prepared to discuss that issue. Maybe we need some staff information. It's better to put it on the next agenda. I suppose if it's a routine administrative matter, or if it's solely a matter of non-controversial update, maybe that's okay. There's actually been litigation around this issue of things being added to the agenda or using intentionally vague agenda titles in hopes of trying to head off controversy. Usually what happens is maybe you headed off some controversy on the front end, but not so much on the back end. Because once people find out that you talked about it, they're not only going to say, well, I'm really mad about that. They're going to say, well, you might have violated the open meetings law. So be careful in that regard. Okay. We talked about civility and respect. Next slide. All right. I thought I had a slide on this, but I didn't. I guess I didn't. On the flip side, the transparency is the expectation, but under state law, it is sometimes the case that a board can have an executive session where you can have a private conversation, okay? But that's only for a very limited number of topics. Things like consultation with your town attorney for specific legal questions. You can have an executive session for determining positions relative to matters that may be subject to negotiation or instructing negotiators, right? Or you can have an executive session for a personnel matter. But as I said earlier, whose job description involves personnel matters? So the only body that would probably ever in this organization have an executive session for a personnel matter would be the town hall, never an advisory, right? Now, and if you're ever thinking of having an executive session, a couple of things, you can only have an executive session after you've properly convened a public meeting. And if you're going to go into executive session, absolutely, Nate needs to be there, or Becky, or your attorney, to guide you through the specific procedures for calling an executive session. You have to make very detailed announcements on the record before you go into executive session. If you make a misstep regarding any of those procedures, then someone challenges you on that, you're going to lose that case, and it'll be like you never even called an executive session. The court will require that the recording of the executive session be made public. So I think the takeaway is, if ever you have that thought, you want to consult with staff, make sure they're on board, use executive sessions very sparingly. Okay. Any further questions on that? Yes.
Nonprofit organizations and conflicts of interest. We have some nonprofits here locally. Our understanding is that the statute says you can declare it, but you don't necessarily have to recuse yourself from a nonprofit decision that might come in front of a board. Yeah, we've actually had some printouts.
Could you clarify what you mean by a nonprofit? I mean, because some people get paid in a nonprofit, by a nonprofit organization, you can be hired.
501c3. Well, say for example, we have people that are directors on our trails group. It's a nonprofit organization. Now, they will be.
I think you've got exactly something.
Well, the situation is, as a director on that nonprofit, my understanding is that I don't necessarily have to recuse myself, but it would probably be wise to do so for the perception.
Yeah. So my radar that I mentioned at the beginning is going off here, and I'm going to give you my thoughts. And then you've got, this is a pending situation for which people needed advice on this. I'd first suggest you consult with the town attorney. Becky may have some access to some resources, but recognize this also, that in matters of ethics, your town attorney is not your own personal ethics advisor. Now, they've got a lot of familiarity with the terrain and they can tell you how the rules work and give you suggestions, but they're not your own individual attorney in that regard. So let me set a little bit of the table on conflicts of interest, and I'll get to that question. But before I do that, are there any final questions on transparency stuff? Okay. Commitment 4 is to commit yourself to ethical conduct. And I just want to briefly touch on 3 topics, given the time we have. First, you want to become familiar with the laws that govern the expectations around your conduct as elected officials. Those rules are actually, for a statutory town, they're in the state code of conduct, which is in Title 24, Article 18, Colorado Revised Statutes. May seem like it's in some far distant place, right? It's not right here in something that we hold on to every day, but go find it. Staff will get you a link to it. And I know it's a lot of legalese, right? But you want to read that and get a working familiarity with what those rules are and what the expectations are. And I would dare say, make it your best friend, right? That sounds odd, best friend. It sounds to me like a bunch of traps for the unwary. But the way it really works is if we have a good working understanding of what the rules are, then we're prepared to spot issues well before they become crises. And we're also prepared to handle conversations around ethics. Because, I get it, sometimes elected or appointed officials are on the receiving end of an ethics concern or assertion or allegation that might be reasonable and well-founded. In fact, it might be something that really needs some attention. Other times, elected or appointed officials are on the receiving end of an accusation of a conflict of interest or something that's like way off the dartboard. Now, here's the right. You have a conflict of interest because you do this. Well, if we have a good working familiarity with the rules, we're prepared to have that conversation. You can say, well, I'm sorry, dear citizen, I respectfully disagree. I understand what the rules are around conflicts of interest, and saying that I have a conflict of interest simply because I, live in town, no, I don't. But it helps show that you're familiar with what the rules are. Okay, let's dive into a couple things. And here, this is one of the handouts that we're going to work off of real quickly. Gives you a little bit more information. Let's talk about conflicts of interest first by identifying what is a conflict of interest situation. So just remember, in general, a conflict of interest situation arises when your board is going to take some kind of official action that directly and substantially affects your own personal financial interest. Okay, so I'll give you an example. The Board of Trustees is responsible for liquor licensing, correct? Okay, so if we have a new proposal for a new liquor license and you're on the Board of Trustees, you be a 50% owner of the limited liability company that's requesting that liquor license, you're in a conflict of interest situation, right? What are my responsibilities? I have to disclose to the Board of Trustees that I have a conflict of interest. Right at the outset, before we begin the discussion, I have to recuse myself from the discussion and the vote, right? And I have to refrain from attempting to influence my fellow decision makers. Here in Green Mountain Falls, do you leave the room after you declare your conflict?
I've had planning commission folks actually do that.
Yeah,
That's what I used with some other previous.
right. It's actually not required under state statute, but I like to frame it in terms of my, fiduciary responsibility. I'm not so worried about the person with the conflict, stepping down from the dais and going to the back of the room and sitting there going, good comment, bad comment. But I am worried about, for their own personal protection, I'm worried about this. Remember the last piece that I said is, right, they must not attempt to influence the fellow decision makers. So what if you're in that situation and the board, you've done everything right, you step aside, you go to the back of the room, and somebody on the board says, well, I've got some questions for the applicant. And you're the one with the conflict, you're the trustee with the conflict, you've done everything right, but you say, oh, I can answer those questions. Oh, okay, step forward. How big is the new tavern going to be? Oh, well, that's easy enough. That's objective. It's going to be 2,000 square feet. Oh, and by the way, we're going to have plenty of parking, and it's going to have a beautiful facade, and we're going to have wine tastings, and it's going to. Does that? What does that sounds like? Influence, right? So I say that to you to help protect you individually. I don't want you to face that accusation that somehow you did everything right, but at that last piece, you got ensnared where somebody thinks that what you did was an attempt to improperly influence. So it may sound unfair. You may be thinking, wait a second, how come I, like every other applicant, can't stand up and advocate for my own interest? Well, remember, only 5 or 7 individuals in this town get to be a government official on that board. That's just part of it. So in those cases, I suggest you get a representative to do your presentation and your speaking for you that takes you out of the crossfire on that issue. Okay, conflicts of interest are not only your own pocketbook or wallet, there are also certain derivative interests. So under Colorado State statute, a financial interest that triggers these conflict of interest rules can include a substantial interest you hold in terms of the following. It could be an ownership interest in a business like a corporation or an LLC. It could be if you're an officer or a director of a corporation that's appearing in front of the board. It could be an employment relationship that you hold with an entity that's appearing in front of the board. Now let's talk about nonprofits. And again, this is my 2 cents. You've got a pending issue of the day, then check in with your attorney and staff as appropriate. Great question, because it was a mystery that confounded me for 20 years. Then the state legislature jumped in, and they added a provision to the Colorado Code of Ethics that says for municipalities that being both a member of the governing body of the municipality and being a director of a nonprofit is not in and of itself a conflict of interest. If that's all that's going on. I don't have the exact language in my head, but it goes on to say that the additional conflict of interest analysis and the obligation to disclose and recuse may apply if there are other relationships going on, such as that person also is a paid employee of that nonprofit or is a recipient of services from that nonprofit and therefore would personally benefit by the decision of the town board with respect to the receipt of those services. And there's one other that escapes me. So there is a specific rule. Your town attorney can give you the statute. You can ponder how that works. Okay, is that helpful? And I wrote on our website at www.CIRSA.org, I think if you probably word search nonprofit boards in our search feature, you can find an article that I wrote about that particular issue a couple of years ago.
Yeah, I'm ex-federal, so we had to also deal with perception.
Yeah, so that's my wrap up about conflicts of interest. Almost all codes of conduct say that appearances of impropriety matter. And there's sort of this risk that's above my pay grade, right? Now we may clear all of the analysis, talk with whoever we need to talk to and come to the conclusion that under the legal rules, I don't have a conflict of interest and therefore I can participate, right? But will it leave an appearance? And that's an individual call you have to make. Are you willing to live with, right? And work through the residue that appearance can create. And quite often people say, yeah, I understand that. I'm prepared for that. I'll be transparent and tell people where I'm coming from. And if it creates an appearance, I understand that, but I'm doing what I believe I'm allowed to do legally. In my view, involved is fork in the road, by the way. Right? You'll get at some point when you're doing conflict of interest analysis, it's my issue only. And I come to a fork in the road, it says, Do I have a conflict of interest and I'm going to step aside, or do I go through the analysis, determine I don't have a conflict of interest and therefore can participate? But at that fork in the road going that one direction may leave an appearance of impropriety, may have an impact on your colleagues, may have an impact on the organization. From an attorney's perspective, I say, well, it's still legally compliant. That's why I say it's above my pay grade, but it can still have an impact. Okay. The other tool that I recommend in all this is that if you have one of those situations and you decide you clear all the legal requirements, you don't have it. Sometimes don't underestimate the value of what I call a curative distortion. Like sometimes there'll be this view or suspicion. Why is that person still up there? I thought they had, some relationship. Just be transparent. Tell people where you're coming from. Hey, Chair or Mayor, before we start, I just want to address something. There's been a question that's arisen about whether I have some obligation to recuse myself in this matter. Here's my example. I just want to make it clear that I don't have any financial relationship to this applicant or to this member or to this matter that we're considering. And here's what the actual relationship is. Just want to make sure everyone understands that. And I intend to approach this matter solely in my capacity as a town official, solely with reference to the town's best interest, and I believe that I can do that. And that has a nice impact. You got to walk the walk and believe it. But if you do those things, I think it has a nice effect. It helps everybody see where you're coming from. Yes, sir.
Any advice on how to handle accusals via Zoom meetings?
Oh, boy. Well, handle them right up front. The law, when you say the minimal disclosure is, I have a conflict of interest, I'm going to recuse myself. And then you step aside or you turn off your mic. I've found over the years that what happened is like you leave the room and then what's going on? Everybody left behind is like their hair's on fire. What's the conflict? Oh my gosh, they must be so corrupt. So you use the disclosure, right, as an opportunity to show that you understand and make a full and transparent disclosure. It tamps down that speculation and it makes a nice record of exactly what the nature of the conflict is. So yes, it's legally sufficient to say, Mayor, I'm going to recuse myself, I have a conflict of interest. But I think it's better to say, Mayor, I'm going to recuse myself, I have a conflict of interest because the person who is up for a potential award of this contract is my spouse, or I have a 25% stake in the company that's requesting this application, or whatever it may be. And I think that's very helpful. So, any thoughts, questions around this stuff? All right. Let's move on to confidential information. So not always, but once in a while, probably less so for the advisory board, once in a while you're going to become in possession of confidential information of the town. It might be an attorney-client memo. Those are easy to spot. Because is it Nina, your town attorney? I'm sorry, Nina's doing some land use work for you. Jeff's going to stamp it with a big red attorney-client confidential. So that's easy to spot. But sometimes it may be something like an appraisal or a deep background memo that Becky prepares and sends out. It's mysteriously called work product, right? So if you're unsure whether a document is confidential or some bit of information is confidential, just ask. Just ask. If you ever have an executive session, we owe each other in this organization a fiduciary responsibility to protect the confidential information that was discussed in the executive session. So a good tool I recommend is before you leave an executive session, somebody ought to be saying, of all the confidential information we've just discussed, which information, if any, leaves this executive session and who are our spokespersons? And everyone else, I think, is duty bound to honor that, even if you disagree. Right? You could have voted against going into executive session, but now that you're in there and you're a participant, that fiduciary responsibility to protect confidential information sticks to you as well. Okay? All right. One last piece, getting beyond your, I need to touch on gifts. The advisory boards, you don't get paid. Town board members, do you get a little monthly stipend? You don't get one either. So it isn't the big salaries that bring it to public service, right? And I'm also here to tell you it's not the gifts, right? It's the love of community that brings us to public service. But more seriously, there is a There are rules in Colorado about gifts to elected and appointed officials. It's even in our Constitution. And there's a lot going on there, but I got two simple sentences for you to boil it down. And it's this: as an elected or appointed official, do not accept any gift of more than $65 if it's in any way related to your role as a public servant. That'll keep you out of harm's way. Subject to one huge caveat: don't accept the gift no matter what its value. If it's obvious to a reasonable person that the gift is being offered to you to curry your vote or your action on something pending in front of your board, or to reward you for some action that you took as a government official. So much about gifts is just the timing and the context of doing the right thing. And you're not alone, big or small. All organizations, we have friends, colleagues, acquaintances. We know people in the business community. We know people, but wouldn't it be odd? We may be good friends with that person who's proposing a new liquor license. And they may be personal friends, but we don't have any financial relationship to them. But wouldn't it be odd if the week before their application was up, that's the week that they want to offer you tickets to the Nuggets game? Not a good idea to accept those. Right? By the way, are those worth, if they got it, still be worth $65, notwithstanding the last 2 games. They're worth a lot more than that. So much is just about context, right? If the gift looks weird and it's coming from places like you're thinking, does this have something to do with me being a government official? Then just decline the gift and it will be a sense. Okay? There are exceptions that are listed and staff can give those to you at some point. Next slide. Beyond ethical conduct, make sure we commit ourselves to high standards of personal conduct, how we conduct ourselves with each other as board members. My list here is a list that myself and our executive director put together of things that people ask us about at CIRSA, because they're saying, CIRSA, do you have any guidelines that you can help us with? Because on our board, we've got some of these dynamics going on. And aren't there rules that will fix this? And I used to say, well, the primary fix is to commit ourselves individually and as a body, have open and honest discussions if we have concerns, and to try and resolve these issues before they overtake us, right? From wherever the perceptions come. And if there's a fermenting concern that our board and commission, it feels like there's people that have better information than others, or that some portions of the body are dominating the conversation to the expense of other members, can we find a safe, respectful place to talk about those things and try and fix them? And it all boils down to commitments of mutuality, of respect, and so on. All right, next slide. All right, my last primary suggestion is to talk about due process stuff. And I know this is primarily for the Planning Commission and Town Board, but I hope it's of interest to everyone. So a lot of the time you're acting just as policymakers, making general rules, master plans, policies that apply to everyone in the town and no one in particular. But at other times, the Planning Commission and the Town Board are going to be making decisions that affect individuals' protected property rights. Things like a variance request, or a liquor license request, or a development plan request. I think your fence permits even go in front of the board, right? And in that role, we're making decisions involving a specific applicant and their specific property rights. And we know it looks a little different because we do a couple of different things. We usually give more notice. We have a noticed public hearing, right? And at that public hearing, that's where anyone who's interested comes and gets to offer their evidence and testimony in a setting where everybody else gets to hear it, right? So we've got a notice and a public hearing, and we're going to make a decision that's based on the existing standards that apply to that decision-making process. And finally, the decision is going to be made by a fair and impartial decision maker. That's the Board of Trustees or the Planning Commission. And when I say decision, it doesn't matter whether it's the final decision or the recommendation. Okay? When we're doing all those things, what does that sound like? It sounds like those people are sitting in judgment. They're acting like judges, making a decision about someone's property rights. We call it quasi-judicial, but it really is a judicial role, just like a judge. And there are new rules that apply, right? That require that we remain fair and impartial and make our decision based solely on the standards that apply. And people always ask me, go, where does this come from? Why can't we just say yes or no because we like to have it, or because I'm personally opposed, or something like that? It all comes from, we all know where it comes from, the due process law. No person shall be deprived of life, liberty, or property without due process of law. What an awesome power we have to make those decisions. And we want to. We, the town, want to decide whether that development gets our approval or whether that liquor license gets our approval. We don't want the county making that decision or the state. But if we want that power, then the people who make those decisions, right, those 7 people or those 5 people have to be committed to respecting the principles, the rules of engagement or due process. Okay? Next slide. So the last bullet here is to be respectful of your time, because we've only got a couple minutes left, is 2 links to basic training for quasi-judicial decision makers to further explain what this process is and what the rules are. But a couple of tips for you folks in that regard. So for the quasi-judicial matters, as the decision maker, you need to understand that we need to limit our involvement in that process to just the public hearing. In stark contrast to general policymaking, for these public hearing matters, we can't be out in the community talking to the citizens at the grocery store or having a phone conversation with the applicant about why I'm going to vote yes or no. Analogize it to a judge. Does the judge do that? Right? No, the judge waits till the trial. And the judge isn't making up his or her mind before the trial. And at a local government level, we have the same obligation, right? So we have to remain neutral. You don't want to be the person, if you're on the board of trustees and you don't have marijuana here, right? So I've seen this a little bit to give you a war story. You don't want to be the one, so a lot of boards, they do decide, they do have marijuana licensing, and that's a due process hearing. You don't want to be the one the week before the hearing quoted in the newspaper saying, I will never vote in favor of another marijuana license in this town again. Does that sound like a fair and impartial judge? No, right? So you can see it's kind of a lonely part of the job, but you have to be fair and impartial, wait till it's right. And you have to commit to not getting lobbied by people or engage in lobbying with people, or worse yet, you may have, after reading the packet, a view in your mind that says, well, I don't think I'm going to be in favor of this. Oh, and by the way, I'm not in favor of it, and I want to make sure that people who might not be in favor know about it. Do judges call people and advocate that they show up at the hearing to help support a no vote or a yes vote? No. So that's what my handout touches on. It explains a little bit more what the quasi-judicial process is and what your responsibility is. So the last piece of this, just to touch on it real quickly, is when you're in that quasi-judicial decision-making process, when you're done with the public hearing, you have the staff present and the applicant present, and the public makes its comments. Now we bring it back to the town board for discussion. That's our deliberation. That's a very important piece of the hearing. That's where the board's going to talk with each other about the reasons they're going to vote yes or no. At that point in time, we at CIRSA love it when you have a good, healthy discussion about why you're going to vote yes or no. When you do that, have in hand the staff report and the criteria that apply. Okay? Sometimes it's off to kind of a rocky start. Maybe it's a liquor hearing and had a good hearing, and I say, Mayor, yes, I'll start the board comments. I'm going to vote no because I don't drink. Or I'm going to vote no because I don't like it. So on my first example, staff's going to jump in and say, wait a second, the fact that you don't drink is not one of the permissible criteria under Colorado law for voting yes or no. There are criteria that apply, but it's a little more nuanced than that. It's things like, is the new liquor license premises at least 500 feet from a school? Is the applicant of good moral character in contrast to being a 6-time convicted tax felon? Those kinds of things. But your staff report is going to have all those criteria, right? So this part of the job requires that we set aside our personal preferences and apply only those criteria. But my second example is that I'm going to vote no against this development application. Do you have special uses or conditional uses? Is that what they call them? Especially, Mayor, yeah, I'll start the discussion. I'm going to vote no because I don't like it. Yeah, that's kind of a rocky start, but we can fix that just by having the other members turn to each other and say, well, why? I call it Sam's rule of why. Why don't you like it? Well, I don't like it because I don't like the applicant. Oh, mistake, we're going to set that one aside. But I don't like it because the building is too tall. Oh, well, now we're getting somewhere because that was one of the issues addressed in the staff report. And that's one of our criteria. Does it meet our development criteria? Or maybe it's even more nuanced than that. I don't like it because it's not compatible with the neighborhood. That's a common development criteria, right? Okay, well, just drill down to the next level. Why isn't it, in your, fellow trustee, why in your estimation is it not compatible with the neighborhood? Oh, because they're proposing that it's got all this glass and, or maybe it's 100% Adobe or something goofy. Or do you like Adobe? I don't know. Whatever it is. But it's something that's not in your development standards. Now you're having a good, healthy conversation of why. From our risk management standpoint, what you're doing is you're making a record, a defensible record of the reasons why you're going to decide that case one way or the other. Now, if all the evidence points to they meet our criteria, right, and all the evidence is pointing to we must, approve this application, then that application is going to get approved. Even if there's, a packed house. Sometimes these hearings can have a little bit of the ships passing. Meets all of our criteria, ought to be approved because you got a room full of people saying vote no. This part of the job is not for the faint of heart. It's not a popularity contest, right? It's about applying the standards and criteria to that. If your staff's going to support you and help guide you through that process. I know I covered a lot here, but if you're in that land use or licensing context and ever you've got some questions. What's my role? What are the standards? What's our process? How do these criteria apply? Staff, help me understand what our role is here. There are no silly questions from where you sit, and you deserve and should expect support in helping you make those decisions. So if ever you need it, just reach out and ask for it, and that'll help you stay out of harm's way. Okay, so move on and wrap it up with getting out of the weeds. My last suggestion for you is to embrace wise leadership as a board, right? Commit yourself to no surprises approaches. Your meetings ought not to have this dynamic where there's new surprises that pop up, and certainly ought not to have gotcha moments. Certainly not to be kind of a staff bashing session dealing with staff. Be respectful, recognize that those things have significant impact if we're saying something untoward towards staff members. As I hinted at earlier, it's a wise body that deals effectively with discord. It's naturally the case that on a 5-member or 7-member body, we're going to have disagreements. But we can have disagreements without being disagreeable. Oh, and by the way, in Colorado, we're by law, by tradition, we're nonpartisan, right? So we don't have to, whatever lack of stability or problems are going on around partisan issues at the state or federal level, you don't have to allow that to invade your work as a body, unless you wanted to, but then you need to be prepared to deal with all of those issues, right? So we can find the time, don't let discord drive your agenda of how you deal with each other. Commit always to civility and mutual respect. That's probably my biggest takeaway in my trainings. And always keep in mind that as the fiduciaries of this organization, as its leaders, keep in mind that you're the stewards of the town's best interests and assets, and that'll serve you well. I think we're done, or we got, yep. So with that, I want to thank you all very, very much for allowing me to come down and present. I'll open it up for any final